welcome to the AZHA Institute. It's my pleasure to welcome you here tonight for this event. My name is James Patrick Sexton, and I'm a PhD researcher in international law here at the AZHA Institute. So this evening's event is called Secondary Sanctions and the International Legal Order. And we have an excellent lineup of speakers tonight who I will introduce shortly. So tonight's event is organized in cooperation with several different organizations, and I would like to thank them for helping to make this event happen. So we have organized this with the Ghent Roland Jacquemijns International Law Institute, the Utrecht Center for Regulation and Enforcement in Europe, the Utrecht University Platform on Peace, Security and Human Rights, as well as the Multidisciplinary International Network on Sanctions. So a couple of housekeeping points before I pass over to the panelists. So after a short introduction, we are going to be having two panels, each of around 45 minutes. As we have quite a packed schedule, I'll try and keep strict timings with the speakers. And after each panel, we will have a Q&A session. So I will ask you, the audience, to keep your questions until the Q&A sessions. I should mention that this lecture is being recorded and will be uploaded to our YouTube channel in the coming weeks. So please keep this in mind if you would like to ask any questions. So without further ado, I would like to introduce Professor Cedric Ryngaert, who is a professor of public international law at Utrecht University, and he is going to provide us with our introduction.
Thank you very much, James, indeed. So good evening, everyone, and thanks for coming in such large numbers as well, even if it is American election night today, as you know. But we will stop on time so that you can head towards election night. And I understand that at Nieuwsport in The Hague, there is an event starting at 8 p.m. today, or you might go elsewhere, obviously. But this American election has a link with our event today. You may have guessed that, although it was not done on purpose. Actually, Larissa, you pointed it out to us. Hey, it's American election night. And I thought, hey, but there is a link. Because for the United States, sanctions, including secondary sanctions, are one of the preferred tools of statecraft, have become over the years. And I think there's more or less bipartisan consensus on this issue, so whether it's Trump or Harris, probably there will be continuity, but you know, Trump is a particular fan of sanctions, a particular fan also of secondary sanctions. Some of you may remember that in 2018 he tore up the Joint and Comprehensive Plan of Action for Iran, and then he went on to reimpose sanctions against Iran, including secondary sanctions on those who do business with Iran, for instance, EU companies doing business with Iran. So in fact, here already we have a definition. First, primary sanctions. Primary sanctions are measures that restrict economic, financial transactions between the sending state, let's say the United States, and then the target state, let's say Iran. But then you have secondary sanctions, and secondary sanctions amplify the effect of primary sanctions in that they restrict transactions between a third state and a target state, a third state, let's say a member of the EU, like the Netherlands. And these secondary sanctions, they prevent what they call sanctions leakage, maybe a term you have already heard of. They prevent traders in third countries from picking up the business of American firms and continuing to trade with the target, undermining primary sanctions. So then secondary sanctions give a sanctions regime global coverage, a comprehensive coverage, and they do so in a unilateral fashion and in an extraterritorial fashion, and that is what makes them problematic, perhaps, and controversial. But more on that in a minute. At this point, you may perhaps wonder how a state like the United States can actually enforce a secondary sanctions regime. The US can not normally just send troops to Europe, for instance, to arrest sanctions busters, although with Trump you never know, obviously, Hague Invasion Act and things like that. But US enforcement authorities have indirect means measures at their disposal. And often these secondary sanctions are what they call menu-based. So there's a whole menu which law enforcement authorities can choose from. For instance, they can bar foreign firms from accessing public procurement, capital markets, or from selling goods in the United States. Alternatively, the US may also impose fines on firms, sometimes billions of US dollars, as you may know, or they may even imprison natural persons, sanctions busters, which they can lay their hands on. Although this will normally only happen when there is some link with the United States, some nexus with the United States. So sometimes one refers also to extended primary sanctions in this respect because there is this connection with the US. But in reality, the connection with the US can be relatively weak, tenuous, such as using a US correspondent bank account, which is often necessary to clear transactions denominated in US dollars, and then you fall foul of US secondary sanctions regimes. Also, the US has imposed export controls, extraterritorial re-export controls, which bar foreign firms from exporting goods made with US origin items to target countries. Think of our own Dutch chips manufacturer ASML exporting semiconductors made with US items to China. They have to take into account US law. We will talk a lot about the US also later today. But the US is not the only player here, not the only player which may impose secondary sanctions. We, in fact, Tom will discuss later how the EU has recently imposed sanctions against Russia, sanctions which have perhaps a secondary or extraterritorial dimension. And going forward, also upcoming political and economic powerhouses, China, India, may resort to secondary sanctions as a tool to achieve foreign policy objectives, typically of national security related. Now, it will be clear by now that secondary sanctions are quite controversial. In essence, they regulate foreign to foreign transactions, and they raise a host of international law issues regarding extraterritoriality, jurisdiction. Is this all in keeping with the principle of non-intervention, for instance? What about international economic law, trade law, investment law, monetary law? Or are secondary sanctions an acceptable or even a much needed response to violations of peremptory norms of international law? Think of the Russian aggression against Ukraine. What about secondary sanctions? Perhaps we should have more of such sanctions? Question mark. What's the impact of sanctions on an existing contract that you may have? What's the impact on the human rights of persons in the target country? It's the amplifying effect of sanctions. So all these issues are addressed in our forthcoming handbook on secondary sanctions, to be published with Cambridge University Press, which I had the pleasure to co-edit with my colleagues Tom Ruys and Felipe Rodríguez Silvestre from Ghent University. We had hoped that the book would be out by now, but we learned from the publisher that it will be out in December and the latest January 2025. Anyway, there are some leaflets there at the entrance, so please take them with you. 20% discount for that matter if you use that leaflet. So this is an event to mark the forthcoming publication. And we've invited, indeed, a stellar cast of speakers. Some of these speakers are contributors to the volume, and others are commentators. And has already been announced, there are two panels. The idea of the first panel is to look a bit at the legality of secondary sanctions under general international law. The second panel, then, we would look at legality in the more specific regimes of international law, like human rights or trade law or private international law. And we would also look at secondary sanctions more from a practitioner's point of view. I will be happy to join both panels as a co-editor of the volume, and I'm happy to answer any questions, of course, at that point. So let me now thank the AZHA Institute for generously hosting this meeting, and James Sexton also for moderating this meeting. Thanks to Ghent and Utrecht University and the Minos network, and Celia, who will take the floor later today, as a coordinator of the network for that matter. So many thanks to all the contributors to the volume, to the speakers, and to you for spending an evening with us, and I wish you a very insightful evening. I'm happy to give the floor back to you, James.
Yes, thank you very much, Cedric. I think we can move directly to our first panel. So I think, Tom, you will begin. So I'd like to introduce Professor Tom Ruys from Ghent University, where he is a professor of public international law. Tom, the floor is yours.
Thank you, James, and thank you, Cedric. It's a pleasure to be here amongst colleagues and friends in this comfortable cocoon offered by the AZHA Institute, immune to the brutalities of US elections. So as Cedric said before, I'd like to take a few minutes to take a closer look at the EU's position, or let's say the EU's evolving position when it comes to secondary sanctions, as the notion has been described by Cedric before. And maybe three aspects to touch upon. First, the US past practice, its position in the past, let's say, decades. It's the evolutions in the present few years, in the last 2 years since the Russian invasion in Ukraine, and then a few considerations on the future, where to from now. Now, I think that the past is well known to many present here. In fact, the handbook, which Cedric has advertised before, is actually the outgrowth of a conference that we organized in December 21. Publishing can take some time, as you mentioned. A conference that we organized back in 2021 in a completely different era. This is a period where there was a major feud, of course, as you may know, between both sides of the transatlantic gap between the US and the EU on what the EU regard as a major jurisdictional overreach on the part of the US in the sanctions domain. Indeed, the European Union strongly objected following the US withdrawal from the Iran nuclear deal, when sweeping sanctions, including secondary sanctions, were reimposed. And you may recall that just beforehand, the period of the Iran nuclear deal, European companies had just begun re-engaging in trade with counterparts in Iran, had begun making investments in Iran, and only then to realize that upon the US pulling the plug of the deal, they would have to disinvest, would have to put a halt to these newly emerging trade relations. So this had an enormous impact, of course, on EU economic operators, but also, of course, on the EU's own foreign policy, whereas the EU sought to continue to leverage the Iran nuclear deal in its relationship with the Iranian authorities. That effort was rendered moot because of the far-reaching impact of these US, especially secondary sanctions. So a major transatlantic rift at the time, but this was, of course, not a completely novel phenomenon. Indeed, let's say the discord between the two transatlantic parties over the reach of sanctions is something that goes back, let's say, at least 40 years, going back to the early 1980s, the time of the US-Soviet pipeline regulations. And there have been constant reiterations of this rift, most importantly when the US adopted the Helms-Burton Act, imposing sanctions primarily targeting Cuba, but of course with major impacts for, again, EU operators. Later on, there are additional examples. Think of the sanctions imposed to impede the construction of the Nord Stream pipeline. Well, we know how that played out. And of course, throughout this period of 40 years, you can say that there's been, in a way, a consistent opposition on the part of the EU, of the European Union, vis-à-vis this perceived sanctions overreach. Consistent objection, sometimes with a certain degree of success, as in the 1990s, when the EU initiated proceedings with the WTO, imposed its famous blocking statute with some success, and some of the sanctions imposed at the time were then suspended. But on other occasions, clearly the EU's efforts to confront the United States have been less successful, including at the time of the Trump administration. I'm not sure if I should say the first Trump administration, when the blocking statute was reactivated, but with little success, causing a headache primarily for EU operators rather than for the US authorities, I should say. So in a way, a consistent opposition for a 40-year span, but that comes with a few caveats, I should add. A few caveats, how come? Well, clearly, contrary to what the EU at times proclaims, the EU also adopts sanctions that are extraterritorial in nature. The EU also adopts on occasion extraterritorial sanctions, admittedly, traditionally building on certain permissive principles under the law of jurisdiction, nationality, and the like. But still, there is a certain extraterritorial reach for some of the sanctions packages adopted in past years. Another caveat, if we look at various fields of EU law, it's clear that the EU itself is no stranger to using its economic clout to project its regulatory force at times on a global level. Think of data protection, think of environmental protection, and the like. The examples, I think, are legion. A third caveat, perhaps, is that the EU itself has never really articulated a very clear position on where it would draw the line between a lawful sanction in terms of its jurisdictional reach and one that overstep the boundaries of what is legally permissible. And there is always a certain ambiguity in the EU's own stance, and I think that's also reflected in the blocking statute from 1996. And let me maybe cite from the preamble sort of the overarching EU position. This preamble states that extraterritorial sanctions that, and I quote, purport to regulate activities of natural or legal persons under the jurisdiction of an EU member state violate international law. And so the determining factor would be the purported impact of these sanctions. This is, just pour la petite histoire, reiterated in slightly different words in an interesting document concluded between the US and the EU back in 1998, a US-EU transatlantic partnership on political cooperation, where the parties agreed, and some of you will be surprised to hear this, and I quote, "A partner will not seek or propose the passage of new economic sanctions legislation based on foreign policy grounds, which is designed to make economic operators of the other behave in a manner similar to that required of its own economic operators." Rather surprising if you look at it from a contemporary stance. Still, if you look at let's say the default position for 40 years in a row, you might say that the US consistently objected to US jurisdictional overreach in the sanctions domain. Has that changed in the last few years? And well, you'll know that since February, March 2022, we've all awakened to a somewhat different world. And this is also clear in US-EU relations on sanctions practice and policy. Clearly, both partners have adopted very far-reaching, innovative, creative sanctions with a view to imposing a cost on Russia following its aggression against Ukraine. And also, of course, while trying to be creative with a view to maximizing the impact of these sanctions, with a view to preventing trade flows from being diverted, with a view to preventing what is perceived as sanctions evasion. One can sympathize with this effort, of course, but the question nonetheless remains, to what extent is the EU now practicing what it has long condemned? So to what extent is there, in a way, a volte-face in comparison to the 40-year opposition on the EU's part vis-à-vis the US sanctions policy? And just to clarify the dilemma a little bit, it's interesting to see that shortly after the after the Russian invasion of Ukraine, the European Parliament expressly called for the option of secondary sanctions. So there's certainly a change in the discourse in the perceived relevance, legitimacy of various types of sanctions. And in the chapter in the book that Cedric referenced, and which I co-authored with my dear neighbor Felipe, we try to flesh out some of the different sanctions modalities, certain types of sanctions, to see to what extent the EU has indeed come to practice what it has in the past condemned. One such example would be the oil price cap. I'm not going into details for lack of time, but as part of the oil price cap, there is, for instance, a prohibition on EU operators to provide technical assistance or financial assistance related to the transport of Russian origin oil to third countries, unless the oil is sold below the agreed cap. Now, one might look at this from two angles. On the one hand, this is, of course, a prohibition imposed on EU operators. So, in one way, it's within the traditional realm of the law of jurisdiction based on the nationality principle. But at the same time, this is a measure with an exclusively extraterritorial purpose. How come? Because the trade in such oil is prohibited on the part of EU companies to begin with. And so the additional prohibition on the provision of financial services, technical services, is exclusively targeted to the trade in oil between Russia and third countries. There's an additional component to this oil price cap in the sense that there's also a clause that provides for the prohibition on access to EU ports for vessels of whatever flag, vessels that are engaged in ship-to-ship transfers involving oil purchased in excess of the oil price cap. That is but one example. There are several others, including in the realm of import and export restrictions. Consider the following: a prohibition on the import of iron, steel, and gold products processed in a third country that incorporate iron, steel, or gold originating in Russia. So, any such products that contain even small quantities of Russian origin iron, steel, or gold would be prohibited from entering the EU market. Coupled to that is a threat of listing third countries that have been identified by the Council as having systematically and persistently failed to prevent the supply, transfer, or export to Russia of certain goods and technology, primarily dual-use goods. The consequence of such listing would be that the trade of such items to those listed countries would in turn become prohibited. A third example that we've touched upon in the chapter it has to do with specific financial sanctions and the threat of criminal prosecution to curb circumvention as such. And one element here would be the introduction of a new novel listing criterion for national persons that are deemed to, and I quote, facilitate infringements of the prohibition against circumvention. But also, this was expanded, this listing criterion, in, I think, the 11th sanctions package, but one loses track after all these packages, of course. So the additional listing criterion would be where a person would be otherwise significantly frustrating EU sanctions. So significantly frustrating EU sanctions can itself be cause for a person's listing with all of the known repercussions, an asset freeze, a potential travel ban, and the like. What to make of all this, and where does it leave us in present and for the future? Well, to come back to my initial question, has the EU come to adopt the very practices that it has previously condemned? We've tried to adopt a nuanced perspective, also given some of the back and forth between the two of us. It's clear that the EU lawyers have been acutely aware of the dilemma of the risk of contradicting their past stance. And we've also gleaned this from conversations with, for instance, people from the EEAS. Just to mention this, by way of example, the last listing criterion that I mentioned pertaining to individuals significantly frustrating EU sanctions, the original language suggested was rather framed in terms of the re-exportation of EU origin goods. That was deemed to go against the EU's traditional position that goods do not have a nationality, so to speak. So that was then altered for considerations related to, say, the law of jurisdiction. So there's been an awareness within the EU of the potential impact, the precedential effect of this novel practice, certainly. And admittedly, in some respects, the sanctions still aren't as sweeping as some we know from the United States side. The US, for instance, is making greater use of actual criminal prosecution to add teeth to its sanctions. Or it also has very sweeping sanctions linked to certain significant transactions, very broad concept, significant transactions or significant investments, for instance, in the Iranian car industry or aviation industry. Compared to some of these more sweeping sanctions, the EU is still adopting a more, let's say, reserved stance. At the same time, it's difficult to escape the conclusion that indeed, in various ways, the EU is departing from its past position. Yeah. Certainly, if you look at, let's say, the preambular language from the blocking statute that I quoted, it's clear that EU itself is purporting to impact trade relations between its primary sanctions target, Russia, and third-party operators of third countries. The same is true. There's a similar dilemma if you look at the examples of US legislation that is deemed by the EU to contravene jurisdictional principles and which are listed in the annex to the blocking statute. If you compare some of these examples identified by the EU with some of the practices that the EU itself has adopted in the last 2 years, then there is, in our view, something of a mismatch. Does it mean that the sanctions are necessarily unlawful? That is not what I have said. That would be, I think, another discussion on which the two co-authors of the chapter might also have slightly divergent opinions. But let me conclude with a few observations. I think it is clear that, firstly, by going down the path of secondary and extraterritorial sanctions, the EU has made it far more difficult for itself to continue on future occasions to maintain its objection to certain far-reaching sanctions imposed by the United States. That may not be such an issue in this era of relative harmony when the two partners are on the same page, certainly when it comes to confronting Russia. But who knows what the stakes are and how the cards are dealt later tonight, and we may all wake up to a different reality where this is very much a concern, a renewed concern, as it was upon the US withdrawal of the Iran nuclear deal. Other concluding observations. A more general one, I think that increasingly, if you see the evolution in sanctions practice, we see that the lines between prescriptive and enforcement jurisdiction, but also between territorial and extraterritorial jurisdiction, are becoming blurred, increasingly so. And I would think that if you adopt a relatively narrow construction of what amounts to an extraterritorial exercise of prescriptive jurisdiction, then ultimately any sanction can be packaged as something escaping from the restrictive impact of law of jurisdiction. It, in a way, loses its normative role. I think that's something to be aware of and perhaps also concerned of. There are alternative ways of construing what's been going on in the past 2 years, and I'll end in just a minute. There are alternative approaches. One could see this novel practice, the EU practice in the sanctions realm, as perhaps a reflection of a novel emerging permissive principle relating specifically to circumvention, evasion. Is there something akin to an anti-evasion principle in the law of jurisdiction? I would say that the EU has certainly not yet clearly articulated such a principle. There has been some support for this in legal doctrine, but it may also be a slippery slope and requires, I think, a cautious approach with clear limits. And lastly, there is also an alternative way to look at the far-reaching EU sanctions vis-à-vis Russia over the past 2 years, namely by, let's say, distinguishing, for instance, between the sanctions imposed on Russia as opposed to those imposed in the past by the US on Cuba or Iran, in the sense, of course, that I think we would most of us would agree that we are confronted since 2022 with a blatant and systematic violation of a peremptory norm of international law, prohibition on use of force, which also in a way triggers a duty to cooperate under the law of international responsibility, not just for Western countries, but for all states around the globe. And the question could be asked to what extent a failure to abide by that duty to cooperate may also translate, may also have a crossover, spillover effect in the sanctions realm. That is something that is a thought further explored by our colleague Stefano Silingardi in another chapter of the handbook. All the more reason to pick up a leaflet and make use of that 20% discount. Thank you.
Thank you very much, Tom, for your intervention. Very interesting. We can now move on to our second speaker in this panel, who is Felipe Rodríguez Silvestre, who is a PhD candidate in public international law, also from Ghent University. So please, Felipe.
Thank you very much, James. Good afternoon, everyone. Thank you for coming this evening for our book launch event. I will be briefly speaking about the chapter that I had the chance to write on my own, because I also co-author one with my supervisor, Professor Ruys. And this chapter concerns the application of the principle of non-intervention to secondary sanctions. Nowadays, as you must have already started noticing, there's a special attention when we speak about sanctions. The focus is always placed on circumvention. How do we prevent circumvention? How do we counteract circumvention? And in my opinion, this has led to a slight disregard of the overall legality of the sanctions to start with, especially in the field of international law. So basically, the question that I try to answer in my chapter is whether international law provides any defense for states who are the victims of these sanctions, and whether in the contrary case, whether powerful economies, whether hegemonic powers can just determine foreign policy for the rest of the world through the adoption of these measures. So I don't need to go over or explain again what secondary sanctions are, although this is not a settled term. It's not a term of art in international law. That's why as co-editors we decided to give every author the freedom to just go on with their own understanding of the term. However, what I do want to say that is this chapter, I basically determined, or I came to the conclusion that secondary sanctions, essentially what they do is compel foreign companies or individuals to comply with foreign legislation, and in the process, obviously, disregard the legislation of their own countries in many of these times. A good example of this is the blocking statute, which has been to a large extent quite ineffective if we look at it from a practical perspective. So having this in mind, that secondary sanctions essentially intend to regulate foreign conduct under the threat of economic coercion, this economic coercion which is basically, I will stop importing items from your economy, I will stop exporting, I will even block my internal market to you if you do not follow my sanction legislation. For me, it's equivalent to economic coercion. And this is where the chapter starts. Just in case I run out of time, I want to clarify at the beginning what are the three main findings of the chapter. So the first one is I basically started by addressing whether economic coercion, whether international law has advanced to the point that a standalone or self-standing prohibition of economic coercion has emerged under customary international law. The answer to that is no, even though, as some of you might be aware, in the period after the UN Charter, especially in the 60s and 70s, we have 3 UN General Assembly resolutions dealing with the principle of non-intervention, which they all include economic coercion in the wording at some point. However, most authors agree that this did not lead to the emergence of a customary rule. And why is this the case? And this is connected to Professor Ruys' intervention, is basically because ever since the 60s, but especially we've seen it in the last couple of decades, there is a growing dissonance between opinio juris, what states and international organizations declare, and what they actually do in practice. And this dissonance, we can see it basically on a daily basis. We see the G7 declaring, well, we're concerned there's this growing instances of economic coercion. However, they only see economic coercion in the actions of their geopolitical rivals. So there we see obviously a problem, because we cannot really state a rule generally if we're only going to say it or we're only going to affirm these things when it's our geopolitical rival. We also see it in the case of the EU, of course. I don't need to go deeper into that because you've already addressed it. But that's basically my first finding, is that there's no standalone rule, and that's the reason for it. So how do we treat economic coercion? Does it play any role? Is it regulated at all? And I think the space for that in international law to this day, it is the principle of non-intervention, the prohibition of intervention. And there, my 2 main findings, the first one relates to the element of coercion, which to this day remains quite ambiguous, quite vague. And we had this 1986 Nicaragua judgment where basically the court, in my opinion, not in a very thorough way, dismissed that certain instances, quite grave instances like a total embargo, a reduction of aid, an imposition of a quota in sugar export, did not amount to a breach of the principle of non-intervention. So for all the light, for all the illuminating aspects of that judgment, I contend that it wasn't really the case when it comes to the principle of non-intervention, and I'll explain why. So basically, when we address the principle of non-intervention, anyone who has attended public international law classes, we always hear of this forcible or dictatorial to speak about coercion, which, again, like the element of coercion, which is the backbone of the principle of non-intervention, which separates just any sort of persuasion or influence from more grave instances of actually attempting to interfere in the domaine réservé of other states. This element, which is so elusive, has always been related to a sort of pressure or compulsion. Some authors even claim that this can only be achieved through forcible means, which would be also a breach of the prohibition of the use of force, which then, if we actually think from a logical perspective, there would be no need for a principle of non-intervention because we already have the prohibition of the use of force, which is at least a bit more clear in the UN Charter. So there's always been this very early, very dated perspective that forcible or dictatorial interference that would amount to a coercive interference. Forcible, we don't need to explain it further. Dictatorial would be basically giving direct orders to another state, do as I command, or you will suffer the consequences. And if we put secondary sanctions next to these two forms of coercing another state, well, they wouldn't really qualify as coercion. Neither would electoral interference through cyber operations, which is also the other. In the last decade, there's been a renewed interest for defining coercion, basically, and it's been sanctions on the one hand, but also, very importantly, cyber operations and how they could potentially breach the principle of non-intervention. So there's a third way of addressing this, and it's by going to the really early United Nations General Assembly resolution that I mentioned, including the Friendly Relations Declaration, which is the most relevant of the three, which speaks about the subordination of sovereign will or sovereign rights of another state. So what I argue in my chapter is that essentially coercion, we have to look, instead of looking at just the strength or intensity of a given measure, of a given sanction, or whether economic measures can even reach this threshold that we have in mind when it comes to coercion, we should look at the intended outcome. And in many of these sanctions, as we've already established, and secondary sanctions in particular, the intention is pretty clear, even in the US legislation and in the US press releases, not just the US, anyone who imposes this sort of extraterritorial sanctions. It is basically to reach as far as possible, to have a bigger impact that primary sanctions would give you, because you know that otherwise other economies are happy to step in and build a trading relationship based on all the trade you took away. So I argue that the intention in this case is pretty clear. And why do I claim that this could amount to a subordination of their sovereign will? And now we move to the second element, which, by the way, at the time I was writing this, a really good illuminating article by Marko Milanovic came out in the American Journal of International Law, which I was happy to see that he also reached the same conclusion that I did, which obviously is a big name. But yeah, he calls this coercion by control, which is basically taking away all, maybe not all, but a lot of your sovereign options or sovereign pathways that you may choose as a sovereign state. For instance, just as in the case of the JCPOA withdrawal, the US basically tells European companies, European banks especially, do not have any Iranian clients, do not engage in trading with Iran, or you will suffer the consequence. Well, it might happen that the European Union was particularly interested, let's say this was the case, I'm not entirely familiar with that, but particularly interested in developing a healthy trading relationship with Iran. For the reason it's because basically foreign policy preferences, trading preferences, as a sovereign, let's speak about countries, it's easier than when we refer to the EU, because you have the sovereign right to determine how to conduct your economic relationships, to determine whether I want to cut or create trading ties or just simply diplomatic ties with another country. So what happens is that I am the US and I'm imposing the sanctions, and I'm partially determining who you can freely establish relationships with or not. So that's basically called the coercion by control, as opposed to coercion by extortion, which would be more in this side of forcible or dictatorial. This is still obviously, I wouldn't call it a novel theory, but it's another way of understanding the requirement of coercion. It is yet to be tested in another court. We haven't had another very influential case, maybe the pending Iran-US case before the AZHA, which speaks about third country measures, as they call it, and not secondary sanctions, might refer to this, who knows, but I believe that this is a more inclusive way of addressing the principle of non-intervention, where the principle keeps its relevance to safeguard sovereign equality, because otherwise we would just left with the prohibition to the use of force, and then we have this principle of non-intervention, which is not particularly useful if we don't really know, or if we just limit it to these very extreme instances of do as I tell you or else. So just to wrap up and to finish with the element now, because I mentioned there's two elements to the principle of non-intervention. We just went over coercion, but there's also the domaine réservé, which is quite a complicated one as well to apply. Basically, there's this knowledge that every sovereign state, as a result, obviously, as sovereign equality, there's this sphere or domain that is protected from outside interference. And it's quite hard to determine what is the actual scope or content of it, because there's not a lot of guidance or international judgments on it. But there is quite a large body of doctrine. There's two positions, of course. There's some that believe that it's basically the concept is virtually empty, because nowadays states, as opposed to 50 years ago, as opposed to 100 years ago, have basically signed treaties, or custom has evolved to the point most aspects of sovereignty are sort of also dominated or regulated by at least a rule of international law. That's the position, for example, of Antonis Thanakopoulos. And there are others, like Vidigal, who believe that even if states agree to certain treaties, or even if certain aspects of sovereign rights are regulated by international norms, this does not mean that third states can just come and interfere in certain aspects. And one of them, and if we keep following this United Nations General Assembly resolutions, would be the formulation of your own foreign policy, the formulation of your own economic policy. So I argue that in certain cases, basically the scale of the secondary sanctions, and also influenced by who is behind them, which is usually very dominant economies, which you're kind of lost if you lose access to their market as a company, or as a state sometimes, because they're sometimes adopted against the state themselves. They could be part of the domaine réservé. The last part of the chapter that I'm not going to be addressing because of time is...
Thank you, Felipe. If you could conclude that.
Relates to jurisdiction, but yeah, someone else wrote a chapter on that on the book as well, so yeah. Thank you.
You read my mind, Felipe. So we move on to the final presentation from this panel. So I'm happy to introduce Professor Larissa van der Herik, who is Professor of Public International Law at Leiden University.
Thank you. Well, it's of course a great honor for me to be in this panel with the editors of this magnificent book and authors of chapters. And I do really think it's a magnificent book. I think that's also illustrated by you, by the great turnout tonight. Unfortunately, it's a very timely book, even if the book is not on time, but it is timely subject-wise. I think it's also, in a way, I see it as a sequence to the research handbook on unilateral and extraterritorial sanctions by Charlotte Beausillon, who's also one of the authors. And I think it's a great sign of the team effort that we so desperately need in academia, that there are these edited works. And I also think actually you need edited volumes for this, because you need so much expertise to really capture all of this. which is very legally technical stuff in a way. So I thought what I would do now is to take a step back and to reflect a little bit on the political environment in which all of this takes place. And actually, if you read the book, and I have read some chapters, I have not yet read it all, but I was already triggered by the very first sentence of the book, and it's also the first sentence in the brief description on the website of Cambridge University Press. And it says, "We live in an age of sanctions." And of course you can say, well, that's obvious, it's a truism, sanctions are the go-to tool. But then I thought about it and I thought, what does this mean to say? If we all agree so easily on it, what does this mean? Is it the same as saying that we live in an age of unilateralism? Or is it even the same as saying we live in an age of disintegration, an age of non-order? Well, one thing is for sure, of course, the age that we're living in today, even if we don't know how to characterize it, may be a very different one that we will live in as of tomorrow. But tonight, we still have the luxury of hope. So, whatever tomorrow will bring, we are living, I would say, in an age in which the system of collective security is under threat. And that is why there is more space for unilateral sanctions, maybe even more need. And of course, because unilateral sanctions have limited reach, there's also need for secondary sanctions to expand the reach of primary sanctions. So that is why we are here. I also think that whatever tomorrow will bring, it is clear that we are somehow living in an age of transition. We are moving towards some new kind of order, hopefully a legal order, but we are in a transitional moment where we see that positions on legality and legitimacy of sanctions are shifting. And I think, again, Charlotte Beausillon in her chapter on the definition, if there is one, or what are we talking about, the concept of secondary sanctions, she also points to this fact that states that were traditionally opposed to sanctions as such are now resorting to it themselves. Russia, China, you also mentioned India, and they may then also at some point resort to secondary sanctions. So we see different potential practice emerging. And I think also the chapter of Tai Tongyen, if I say it more or less correctly, is a very interesting chapter, and he depicts these shifting practices, in particular in and by China. So I think shifting positions, we see them more broadly also of the global south, and on sanctions more generally, so to say. And I think in particular the resolution of the UN General Assembly of September of this year on the implementation of the ICJ advisory opinion on occupied Palestine was very telling in that respect. So you had a number of Western states abstaining for that resolution, including the state that I'm a national of, the Netherlands, and they abstained because they said that unilateral calls for an imposed solution are not helpful, and they expressed particular opposition to paragraph 5, which is the paragraph in the resolution that calls for sanctions, and they were opposed in particular to measures about transfers of arms. And they had a different view on that. Also, Canada abstained. They were concerned. They said this resolution contains language that aligns with the boycott, divestment and sanctions movement, which Canada firmly opposes because it seeks to uniquely isolate Israel. And of course, isolation is typically what sanctions aim to do. Austria also abstained because they said the resolution goes beyond the advisory opinion, including particularly when it speaks about responsibility of third states regarding trade relations with Israel and sanctions, which are not mentioned in the advisory opinion. And they said the broad call for sanctions and import restrictions contained in the resolution do not correspond to any legal obligations of third states. And I think it's right to say that there are no legal obligations, possibly of third states, to impose sanctions. There's a question: is there a right to do so, not an obligation? But of course, it's quite interesting to see these Western states opposing unilateralism and opposing sanctions. On the other hand, we saw states representing or included in the non-aligned movement who were recalling responsibilities of states not to support, facilitate, or cooperate with any unlawful policies and to undertake practical measures to bring them to a halt. So I think it's quite interesting that there is a reversal of the North-South divide, where we see Global North traditionally sanctions eager, we might say, and Global South traditionally sanctions skeptic. And here it was really completely the other way around. And I think that's just an interesting setting to take into account. Now, even if positions on unilateral primary sanctions may be shifting, that is then not necessarily the case also for secondary sanctions, which are, of course, let's say, an animal on their own, which is why they deserve a book of their own. Secondary sanctions are controversial, they're problematic from an international law perspective, and I think that's a message that very clearly comes out of this handbook. Then there is a question, and you already referred to it, Tom. Can there nonetheless still be a legal case to be made for secondary sanctions in specific circumstances, in particular in situations where there is a very serious violation of the most fundamental of norms of the international community, like, for instance, a violation of the prohibition of aggression? Do we then have a different situation, and should we have, in particular in situations where this occurs and where the Security Council is not functioning, should we then not try to think about different types of collective security where secondary sanctions can play a role? And this, well, you already referred to it, but this is really, I think, the core question of the chapter, one of your chapters of Stefano Silingardi. I don't know if maybe he's here or online. I will not present his chapter. I don't think I could do justice to it, but it's just to entice you to buy the book. I think this is really a very good chapter, and really one of the questions that he tackles in his chapter is this question: can secondary sanctions be a tool to operationalize the duty to cooperate, to bring egregious violations of peremptory norms to an end? So the obligation of Article 41, paragraph 1 of the Articles on State Responsibility. So very specifically, and the case study in that chapter, again, obviously, is Russia. And so the question is, if states or entities like the EU impose sanctions on Russia with a view to responding to this violation and with a view to, in a way, implementing their own duty to cooperate to end those violations, and if there then are third states that actually undermine those sanctions, could one say that those third states, which have their own obligation to cooperate, are they violating that obligation because they are so clearly undermining sanctions that have the aim to end the violation? So that is the question that he brings out there, relying on Article 41 as a possible way to justify secondary sanctions in a very unique and limited situation. Now, in his chapter, Silingardi is also very mindful of the risks involved in offering such a legal justification to economically very powerful players like the US and the EU. So what door are we really opening here? And if we are opening this door, that move, he argues, and I would really agree with that, should be embedded in structure that in a way link back to a system of collective security. So you could say that this is only possible if there is a requirement linked to that there should be a determination of a violation made by the General Assembly beforehand, so that states do not determine on their own that there is such a violation and then engage in this type of behavior. So I think we can also think about other requirements. So we wrote as part of the advisory committee on international law to the Dutch government that Cedric is now the chair of. Already in 2022, we also wrote an advice on this question: what are obligations of third states? Then I was still member, now not anymore. But what are the obligations of third states when there is such a violation of a peremptory norm? Can you then take sanctions and justify them as third-party countermeasure? Can there be a place for secondary sanctions? And possibly so, because of course there's a clear gap if the Security Council isn't functioning. So we might need to consider that, but then there need to be preconditions attached to that, a role for the UN General Assembly. Perhaps even you could make a requirement that states should then accept ICJ jurisdiction so that these measures can be litigated. Yes, I see. I mean, yes, in an ideal world, and we're definitely not living in an ideal world. So maybe I will conclude. I think the last chapter that you actually also presented, Tom, you and Felipe analyzed the secondary sanctions that the EU has now imposed, in a way revisiting its earlier position that these sanctions, when imposed by the US, were too far-reaching, jurisdictional overreach. So I think this new EU practice indeed reinforces the need to discuss legality of secondary sanctions and limits. And in a way, you logically conclude your chapter by saying that the ILC, the International Law Commission, should sink its teeth into the matter. Now, I will conclude. I have actually 4 questions to you. And then we can have probably just naturally move into the Q&A. So my first question is, apart from the question, is the ILC capable of doing so, given the political sensitivities? That's not my question. If the ILC were to do that, what, in your view, should be the output or the end product? Should that be core principles, convention? I mean, what should be the end product? So my second question is, in your book you, and also in the presentations, you clearly set out that there are different types of secondary sanctions. And in this panel on general international law, it's also clear that there are different tensions between secondary sanctions and core concepts of international law, like extraterritorial jurisdiction and overreach, non-intervention. But my question is there also scope to look at a particular type of secondary sanctions in their own right? And that is particularly sanctions, secondary sanctions where one state controls a public good and restrains access to that good. So I think, for instance, about SWIFT, which is the dominant financial messaging services provider, and subjected to Belgian law. It's a Belgian entity. So Belgium can somehow, has great power here to decide on access or not. Well, we have the same with ICANN, the entity that allocates and manages critical internet resources, including domain name systems, which is controlled exclusively by the US. It's a US entity. And Ukraine, very early on, they asked ICANN to disconnect Russia fully from internet. And, well, this may or may not be a sanction, but of course the question is, should it be the case that one state decides on access to a global good? And I think even the dollar, we can say, is in a way a global good. It's US currency, but it's also global currency. So is there some merit or legal basis to pursue this line of thinking in relation to this very specific type of secondary sanctions or sanctions that is related to managing access to a global good? I'll be a bit briefer now. Third question, Russia. So Russia is a case study, of course. But my question is Russia unique for the EU, or is it a precedent? So is it a turning point, or is it just because it was Russia and a special history and a special situation that the EU went so far? So is the EU now going on the path of secondary sanctions, or was it just a one-off in a way? And my fourth question is, you discuss, of course, blocking statute in various chapters as a way to resist secondary sanctions. Now, as you know, sanctions are also being threatened against the ICC by the United States. Again, we can say, but this time more far-reaching than the first round, which were problematic in their own right. So, of course, everything depends tonight, but still there might be some bipartisan support for these types of elections. So my question is, do you have any lessons learned on blocking statutes for ICC member states to protect the ICC against the US when we do go into the dark? So, to conclude, I thank you for editing this book, for writing it. I think it's a beacon of wisdom in very dark times. Thank you.
Thank you very much, Larissa, for your intervention and for giving homework to our editors and authors. To save some time for the audience, I suggest perhaps if you each want to take 1 minute to address one aspect of any of these questions, and then we can go straight to the Q&A for the audience. So maybe, Felipe, we could start with you.
Okay. Okay, so I will address maybe the last two, or the one about Russia, whether it's an isolated instance or not. I'm not entirely sure. I do think it's the first time. I think Europe always sort of stayed a little bit on the fence when it came to sanctions, when it came to other instances of international crisis that could have been handled by sanctions, always trying to sort of remain within bounds. Even to this day, the guidelines on sanctions implementation issued by the EU mention Europe does not impose extraterritorial sanctions, even though we can see that that is highly contentious in my opinion. So, because this sort of moment of Europe is also associated with a growing awareness of its strategic autonomy, I don't think we're going to be going back to previous stances. The question for me also is, like, to the EU is whether it's going to become a little bit more evident, more clear, as in we're not going to have to sort of pick and like guess what is the real intention or opinion behind it. So that would be my answer, like whether they're going to come more clear with the legal bounds that they're managing these days when it comes to sanctions. Yeah.
Great, thank you. Tom, please.
Good. Well, Larissa, I much enjoyed the first half of your presentation. The second half calls for another handbook, I'm afraid, to cover all of the questions. I might not single out this one specific question, but just share a few observations. On the question whether the ILC would be capable of taking this project on, just for the sake of clarity, I wasn't saying that the ILC should specifically look into sanctions, but rather we need some clarity more generally on the law of jurisdiction, how it's been evolving over the past decade. So I think there, no other body would be as capable, as well placed as the ILC. As a fallback, in the final sentence of the chapter, there's a reference to a potential role for the ILA or the AZHA. But I think that it's something that the members of the ILC should seriously consider of including. I think a closer look at the topic is long overdue, in spite of all of the great work that Mr. Jurisdiction next to me has been doing over the past years, of course. On whether there's a need for a specific type of secondary sanctions dealing with sort of the hubs in the international economic financial IT system, I'm not sure. I think the question is rather perhaps one of primary law, whether for certain of these global public goods there is a right of access. For those familiar with EU law, you have in competition law things like the essential facilities doctrine, which suggests that if a company has a certain dominant role in a market that's crucial for a variety of players, then you have to grant access on certain conditions, on certain parameters. So I think that's rather something to be looked at from the prism as to whether there's such an obligation to provide access, perhaps to begin with. But a very interesting thought nonetheless. Is Russia unique? Is it a precedent? In terms of EU practice, well, time will tell, but that doesn't alter the fact that a precedent has been created, right? So the genie is out of the bottle, and we cannot, of course, as Western countries, claim that whatever we do is just a one-off exception to the rule and should not otherwise impact what other states are allowed to do. Of course, we have to be cognizant ourselves of the precedents that we create, whether it's, well, let's say the cost of opinion and the like. Any precedent that you use today will be used tomorrow by a potential adversary or a state with different interests, so we can't just, well, you see where I'm going. I'll leave it at that and move over to Cedric.
Yeah, just briefly, indeed, SWIFT, ICANN, dollar dominance, capital markets. I think this is the article by Farrell and Newman, Weaponizing Interdependence in International Security 2019, which has caused, I think, also a shock in the discipline of political science, and then we're engaging with that now from an international law perspective. I have a forthcoming article on that issue, specifically in a Japanese yearbook of international law. I would say, yeah, there is a territorial link. This is how it is justified, right? We have some territorial link, but is it a genuine connection? So we have to go back to first principles, I think. Is it a genuine territorial connection? What about abuse of rights? What about the principle of reasonableness? And what about the principle of non-intervention? I don't think the law of jurisdiction can solve this, because each time you can find some link, whether it's territoriality or these days, everything is security suddenly. So you can justify anything based on your national security. So that does not seem to solve the problem, although, I mean, I've done a lot of work on jurisdiction. I'm also a bit skeptical that the permissive principles jurisdiction can offer a way out of the conundrum here. I think we have to resort to other principles of international law. Yeah, I would leave it at this for the moment.
Yeah, thank you. That's perfect. So we have time for one or two questions for this panel. So one of my colleagues here will move around with the microphone. So please state your name and affiliation, and please keep the question short and address one of the speakers. So the gentleman in the back had his hand up first, and then...
Thank you for the interesting presentation. I'm Michael Strauss from the Centre d'études diplomatiques et stratégiques in Paris. And it would seem to me that secondary sanctions are kind of a formal acknowledgement that, that primary sanctions can leak. And yet secondary sanctions are also sanctions, and conceptually it's like solving the problem with something else that can leak. And it would seem that that could at some point give rise to tertiary sanctions and, you know, a never-ending cycle. So my question is, apart from the same legal issues arising, if the expansion of secondary sanctions moves toward further levels, might different legal issues arise beyond the secondary sanctions level? I personally have no idea at this point, because the thought came to me as you were talking. But if any of you have thought about it, I won't address this to a particular person. I'd love to hear. Thank you.
Perfect, thank you. Maybe we'll take a couple of questions and then we can just do a round of answers. So I think there was a lady here, Rafaela.
Hi, thank you very much. This was very informative. I'm Mina Orar, and I'm with the International Court of Justice. I recognize the difficulties in bringing a case before the International Court of Justice, whether it's a contentious proceeding or an advisory proceeding. But I was curious whether you thought, what your thoughts were about the role of other international tribunals in helping define the legality of secondary sanctions, in particular. There's a rise in investor-state arbitrations regarding sanctions, which could provide an avenue for at least a bit more of a legal discussion of their implications. Thank you.
Thank you very much. And one more question, if it's the gentleman here. Thank you.
Hello, my name is Alejandro Ortega. I'm a PhD candidate at Maastricht University. I wanted to ask, I pick up on something that a bit all of you mentioned, but well, for the 32nd year in a row now, the UN General Assembly overwhelmingly voted to reject the embargo on Cuba. despite all the dissonance that Felipe mentioned, or despite the shifting positions, right? That is the one thing that has overwhelmingly and consistently been rejected by the General Assembly. So I wanted to ask, what does that reveal, really? What does that particular vote in this particular issue reveal? Is it a blueprint, a path that will show the limits of secondary sanctions? Is it just one isolated incident? There was a recent blog post at the European Journal of International Law that said, well, perhaps there is a rule that allows for secondary sanctions, and this is the one exception when it's not. Or is it, I don't know, practical realities, as Professor Van den Herik said, well, these states have now shifted positions, all of a sudden they're now going to say, well, actually, we think that the Cuban embargo is now fine, right? So what does the Cuban example, what does these General Assembly resolutions reveal about this issue? Thank you.
Okay, thank you for the questions. I can now turn to my panelists. Feel free to answer any of the questions. Maybe Larissa, we could start with you and then move along. But also, if you don't want to say anything, don't feel obliged.
Yeah, I'll just be very brief because I feel a bit like an intruder. But on the last point, I think that we need to differentiate between different settings, and I think you also made that point in a way. I mean, so Cuba is in a way, I would say, quite a unique case, and then we have sanctions. That respond, or that respond to agreed, recognized violations of peremptory norms. So that is the Russian case, and I think you can, of course, have legal discussions in relation to both set of sanctions regimes, but they are quite different, I would say, and so that is why I focused on this specific chapter and this specific sanction. I think you see shifting positions of the global South. To the extent that you see them, but only there, and I would say not. I think their general reservation or reluctance or against sanctions remains. So if there's a bit of an opening, it's only in that very concrete and specific setting.
Would any of the other panelists like to answer? And if I could ask you to be brief, please.
Just very briefly, perhaps, on the question what role other tribunals apart from the ICJ could play. It's a valid question. Well, of course, sanctions, including secondary sanctions, also raise interesting questions under international trade law, for instance. But at the same time, we know that the WTO's dispute settlement mechanism is also in tatters. Both with investment arbitration and the WTO system, you also have the relevant question as to what impact the security exceptions in relevant instruments might have, but I think that's something that Geraldo might touch upon just in a minute, so I'll leave it to him to address. On Michael's question, and good to see you again, sanctions leakage, of course, sanctions are the stake of a constant cat and mouse game between the sanctions adopter and the primary, secondary targets. I'm not exactly sure what a tertiary sanction would look like. I'm trying to conceive of it, but you'll have to. Well, my imagination fails me. Well, I think for secondary sanctions, there's a range of specific legal questions that depart, that are additional to the regular questions of legality that you would be confronted with for primary sanctions. And Cedric and I have tried to sort of map relevant legal issues specifically for secondary sanctions in a piece that came out some time ago in the British Yearbook. But of course, there is also the separate discourse on what is the effectiveness of sanctions, whether primary or secondary. It's primarily a question for international relations scholars and economists. One very interesting book that many of you may have read, but which I would recommend, is Agathe de Marais' Backfire. That's really a very accessible account of how this cat and mouse game has evolved over the past years. I'll leave it at that.
The wrong button. Primary sanctions leak, right? Secondary sanctions leak as well. The solution is more vigorous enforcement. That's the easy answer. But one of the challenges is how to deal with cryptocurrencies. So we have a chapter in the book on this. So if you pay via crypto, then you don't use the US dollar, right? So the solution could then be prohibit crypto. I mean, that could be one answer to the problem. Of course, at one point, maybe everyone starts imposing secondary sanctions. That is the nightmare scenario for me, and that would then lead to no longer any interdependence and global decoupling, right? That we don't have anything in common anymore, and maybe that's the future waiting for us tomorrow with the US starting to decouple, and then your sanctions don't bite anymore, right? If you decouple, if there are no trade relations whatsoever anymore, and maybe that is the near future, something that I'm not looking forward to, but that's a concern that I have indeed. Tertiary sanctions, I'm not quite sure how that looks like, but I think we can talk about that over drinks afterwards. Thank you.
Perfect. Felipe, one or two words? Yep.
Just about the resolution, the Cuban embargo, which is one of the 3 resolutions that are adopted either yearly or bi-yearly. I think it's treated as a separate issue, which mainly tackles human rights concerns, as it should. But I'm also, I did the study before, I don't remember now, but there's always a lot of care with the language employed, not to create sort of whether prohibition or permissive rule on it. There's also a lot of care with mentioning extraterritoriality on it as well. So I'm always quite intrigued because also the voting pattern of the EU changed, I think, in the early 90s. I'm not entirely sure. But yeah, every time that there's this wide agreement, obviously the resolution keeps itself very sort of within the margins of what Western states are also willing to accept in order to keep it almost unanimous. Essentially that's my take. 'Cause about the other question from the back, I've been studying the topic for the last 4 years, so it's quite a few specific legal issues that arise from it, but it mainly relates to, sadly, it's a lot of regimes that are quite ambiguous, like jurisdiction and genuine connection, like non-intervention and what is coercion, and WTO being locked. So it's quite of a tricky. That's the added difficulty, I would say, of secondary sanctions. So yeah, thank you.
Thank you very much. So I'm mindful of time, and we have another panel for everyone tonight. So I'm going to ask you to join me in another round of applause for this first panel. So I'm very happy to welcome you back after this short break for our second panel of this evening's event. And this second panel will look at secondary sanctions from an international economic and private law perspective. So our first speakers, I believe, are Dr. Geraldo Vidigal, who is an associate professor in international law at the University of Amsterdam, as well as Celia, who is a PhD candidate in European law at Ghent University. So please, whenever you're ready.
Thank you so much. So I do international law, but I do mostly international trade law. And I'm going to talk a bit about investment arbitration as well. The WTO is having trouble, but as Celia will explain, then through the Court of Justice of the European Union in particular, WTO law can have a big impact on what it ends up being considered permissible in practice, at least in Europe. So I'll do something that I thought my students that I cannot do, which is to begin from the exceptions. So, instead of, let's just assume that there is a violation of WTO law, either some good that should be gotten somewhere, it's not allowed to come in, or there's some violation of the protocol on financial services, or of one of the many rules on financial services in WTO law. They're really complicated and can apply in some cases, in others not, to some states and to others not. But let's say there is a violation, right? So something that should have happened isn't allowed to have happened. Isn't allowed to happen, or it cannot happen because of some sanctions. And here we're going to look into 2 different provisions. One is the security exception, which is what everyone is very excited about always. But what I'm going to argue is that maybe the real exception that will be at play for secondary sanctions will be this very strange exception in Article 20D of the GATT, which is one of the few little-known provisions of Article 20. People like the ones about animals and labor and all that, but this one is about enforcement. So it says that you're allowed to adopt measures that are non-discriminatory and that are necessary to secure compliance with laws or regulations which are not inconsistent with the provisions of the agreement. So it's a provision that allows you to do things that are necessary to be able to enforce other laws that are in themselves GATT compatible. Now, in terms of sanctions, normally, of course, you would go to Article 21, and we do have case law extensive, thanks to partly Ukraine versus situation, but also Saudi Arabia, Qatar, and more recently the US against everyone else, essentially, on steel and aluminium, and then one case, very interesting case involving Hong Kong. What the security exception says is that members are allowed to take actions which they're considered necessary for the protection of essential security interests regarding fissionable materials, traffic in arms, ammunition, and implements of war, or measures taken in time of in time of war or other emergency in international relations. Here there's a big discussion that happened for many years over whether this was self-judging or not. I don't know any panel that has considered that this is self-judging. More recently, if you do investment arbitration, you know there's a case, SEDA versus Colombia, where the tribunal even said that if the provision says, even a provision that ostensibly very much says that it should be self-judging with a footnote to say this is self-judging, the tribunal is still allowed to make a good faith, an assessment of good faith implementation. Now, yeah, the US, of course, every time says that this is completely self-judging, and they essentially can say the words Article 21, and it's an out of jail free card. First of all, if the sanctions concern arms, ammunition, and implements of war, export controls, etc., I don't think there would be an issue because these are, essentially exempted under letter 2, right? So not 3, but 2. So if you're talking about even dual-used goods and what isn't a dual-used good these days, if a pager can be a dual-used good, then who knows what isn't in our phones and our cars and all of that. All of this that where you have data going on. But let's leave this aside and assume that this is not brought into the topic because so far it's untested. This provision. Countries normally manage to agree on this by talking instead of going to dispute settlement. What we do have is significant jurisprudence on this emergency in international relations situation and what constitutes that. And the main thing, and I didn't want to bring a very long text here, is that you need a breakdown or near breakdown in international relations. So political or economic differences are not sufficient to constitute it. And you also have, and this is the sentence doesn't make it clear, but this is in Qatar, Saudi Arabia, where the panel said that the measures adopted by Qatar that affected third states were so remote from or unrelated to the emergency in international relations between itself and Saudi Arabia. So the measures adopted by Saudi Arabia vis-a-vis that affected the rights of European TV companies and all that, because it was a silly case about an authorized pirate network for people to watch the Euro Cup, essentially. So they said that, well, if you're affecting the rights of third states, that's unrelated to the emergency between Saudi Arabia and Qatar. And therefore, it's implausible for the protection it's an implausible measure to do what you say you want to do, which is to protect your essential security interests by blocking out Qatar, because you are blocking out also other WTO members. So I think that's relevant for the secondary sanctions part. But so I think, let's say, so what we have is, let's say, between Russia and Saudi Arabia, between Russia and Ukraine and between Saudi Arabia and Qatar, we had a recognition that the situation was there, right, where there was a breakdown or near breakdown in international relations justifying the non-application of WTO rules between them. So there was not this recognition between the United States and China or between the United States and Hong Kong, because they said, well, these countries continue to cooperate, they look at how much they trade, they have missions, they just have a political or economic difference, and we cannot allow any political or economic difference to rise to the level of an emergency in international relations. So essentially, what this is saying is that if I have a primary sanction against a country that is committing, one of these violations of the use of force, I would say that this would be, and you, especially if you are directly concerned, that would be very much clear. So, let's say U.S., Iran, I would say it would be difficult. Well, Iran is not a WTO member, but there's all this. You could find a situation that would be emergency in international relations. But there also has to be a connection between the measure you're adopting and the relevant situation. And I'm not going to go into the ICJ case law, because there, of course, you have the question whether the security exception justifies the adoption of certain measures that didn't come into play, but it eventually will, and also before investment tribunals. But the question we're asking here doesn't concern this primary sanction, but I'm just trying to explain this because, of course, once you have a valid primary sanction, then you could have also valid secondary sanctions under Article 20D. And the question is, and then the questions that are going to be asked is, the first one is this: so are the primary sanctions WTO compatible? Because the law regulation has to be not inconsistent with the provisions of the WTO law. So you have to make an assessment of whether there is a valid primary sanction. And then the second question is, are the secondary sanctions necessary to secure compliance with these primary sanctions? And then the question of whether something can be necessary, especially if it's extraterritorial and you're going very far, is going to be an interesting question to ask. We do have, again, a lot of jurisprudence on necessity, but essentially the elements are: how trade restrictive is this, how important is the objective, and how much does this contribute to the objective? And maybe, you could end up having an assessment, a substantive assessment of, is this measure that you're taking necessary, or are you going too far? And then the third question would be, are the secondary sanctions being applied in a non-discriminatory manner? And then I'm not an expert on the sanctions themselves, but it seems to me that they generally are being applied in a non-discriminatory manner. That said, all you have to do is to find another member that isn't being affected, right? So essentially, if the US, for example, would apply sanctions on EU companies, but not on Canadian companies or Brazilian companies, that might be an issue. And so this is going to be the framework that will be applied by WTO, probably also by investment tribunals, because many of these provisions are formulated very much like the WTO security exceptions, and they have the general exceptions also as well. So in the end, I think that's going to be relevant, not only through the WTO law itself, in which of course you can have a conversation, but through these other adjudicators that end up entering into dialogue with WTO law, of which the Court of Justice of the European Union. And with that, I pass the floor to my colleague.
Thank you so much. Of course, being probably the only panelist that is not specialized in international law, we thought that I would remain within the safe area of EU law, which is more my area. And we thought I could give perhaps a few words about the Court of Justice case law on these matters. So of course, when it comes to secondary sanctions in the EU case law, we haven't had much development so far. We've had two cases about the application of the blocking statute, but of course that concerns a different scenario. However, there are still elements in the Court of Justice case law that might be interesting to keep in mind to inform the debate on secondary sanctions. And here I'll focus briefly on three main points. First of all, the Court of Justice has, in sanctions cases, systematically dismissed claims based on infringements of WTO law or international law. We've had the Rosneft case in which the applicants argued that there had been, in the case of exports of oil drilling technologies, I think, an infringement of the GATT, and they were also arguing that since they're alleged there was also a breach of the EU-Russia PCA, which was meant to implement the GATT, then by extension there was an infringement of the GATT. The court said no. The court said that the GATT was not directly applicable, but even if it were, then we have, as Geraldo said, Article 21 security exemptions, and the Council could, in its discretion, consider that we had a case affecting the EU's essential security interests. The court basically applied the same reasoning as in a case where a Russian bank invoked the GATS this time. So same here, GATS was not directly applicable, but even if it were, we have the Article 14 bis that provides for security exceptions. And finally, we've had the more recent case of Venezuela versus Council, where Venezuela argued that the restrictive measures against it were unlawful countermeasures that were infringing international customary law and also the GATT. The court said no, once again, and it said that these were not countermeasures due to their primary aim. The idea was not for the EU to respond to non-compliance by Venezuela of its GATT obligation by in turn not complying with its commitments. What the EU was doing was replying to the internal human rights, rule of law situation in Venezuela. Therefore, we were completely out of the realm of countermeasures, and we had no infringement of the GATT either. So, of course, it seems that here the answer of the court has been every time quite short, the court not being really willing to engage in these arguments, but then we, of course, can wonder whether the outcome would be different in the case of secondary sanctions. The second main point was I thought I would mention that some applicants have been increasingly making claims that the sanctions imposed against them were extraterritorial and had unlawful extraterritorial effects. Same here, the court has barely engaged with the argument. In the case of asset freezes, well, the court said no infringement of the principle of territoriality because this concerns assets located in the EU. Same with sectoral restrictions such as export restrictions. True, sanctions do aim to have an impact on the targeted state, but then they apply to EU operators, or at least, as the court said, persons in situations that fall within the jurisdiction of the member states rationale loci or rationale personae. And finally, we've also had the argument that supporting measures like the reporting obligation for listed targets, you might remember that the EU adopted the provision that forces the individuals subject to asset freezes to declare all their other assets within the EU, of course to tackle circumvention. Well, they were saying that this was going too far and was going beyond the scope of EU territory. The same here, the court said that there is a sufficient link to the EU. So of course, again, the court has not really engaged on that, but we can wonder if the court was faced with secondary sanctions, would it still require this sufficient link? How would it approach it? If the court was found that a sufficient link was missing, would it consider that the Council has a broad discretion to impact the targeted state? Of course, these remain questions that are in the open. And then finally, very briefly, of course, there's a question of how the Court of Justice interprets or approaches the objective to fight sanction circumvention, because, of course, this argument has been increasingly made by the Council to justify extending the scope of restrictive measures, of listing criteria, of sectoral sanctions, and to justify their legality in sanctions litigation. First of all, the court has provided very limited elements of what circumventing actually means. The court has said that, these are activities which have the aim or result of enabling their author to avoid the application of the relevant provisions. So that kind of leaves, the open margin of maneuver for the Council to further define that if it wishes. And finally, it's interesting, though, to see that when it comes to arguments based on circumvention, the toll on the Court of Justice has been rather moderate. So the court has accepted that, ensuring an effective application of sanctions may justify extending the scope of sanctions, extending some, adopting new listing criteria, even adopting supporting measures. However, when the Council applies the listing criteria, circumvention does not justify an excessively broad interpretation of listing criteria, such as, for instance, in the case of family members or rationally leading business persons, we cannot interpret the listing criteria of association or etc. in a completely open-ended manner. The Council has tried and failed repeatedly to make the point that tackling circumventions requires to, keep extending the list of targeted people. So, of course, the 3 points are still under debate, might still evolve, but they are still interesting to tackle secondary sanctions. Thank you very much.
Thank you very much. Thank you very much, Geraldo and Celia, for your presentation. So I'm now happy to introduce our third speaker, Dr. Mercédeh Azeredo da Silveira, who works at the AZHA Avocats, Attorneys at Law in Geneva. So the floor is yours.
Thank you so much. Thank you for pronouncing my name so well. A long name. So I'll completely shift the perspective now, and I'll look at sanctions through the lens of private operators. In a landscape in which sanctions programs are multiplying exponentially and are increasingly detailed and intricate, and in which cross-border transactions also proliferate, it has become a very thorny exercise for private operators, for their counsel, their advisors, for domestic courts, arbitral tribunals to determine the effects of trade and financial restrictions on day-to-day business operations and on contractual disputes. And clearly, this endeavor has become all the more complex and challenging as a growing number of sanctions programs strive to be given effect extraterritorially. Some sanctions strive to thwart commercial and financial activities with a target state by imposing restrictions on individuals and entities that are located outside the territory of the sanctioning state, but that are considered by the sanctioning state to fall within its jurisdiction or to be trading in goods or technology that fall within its jurisdiction. Some sanctions go much further, as has been discussed until now, Secondary sanctions, primarily US secondary sanctions, strive to impact transactions that simply have no nexus to the sanctioning state. Now, these extraterritorial and secondary sanctions, they form part of a complex regulatory environment that private operators cannot simply disregard. As was mentioned several times, breaches of such sanctions might trigger severe penalties, hefty fines, imprisonment, you mentioned, for individuals, restrictions on access to the US market and financial system, perhaps even the risk of being designated and having one's own assets blocked, which inevitably incentivizes private operators to suspend the performance of their contractual obligations. Now the question remains, does the fact that a party withheld performance of its obligations in order to comply with a sanctions program necessarily justify its exemption from liability for non-performance? So in the interest of time, I limit myself to 2 observations on this important question. First observation, which is based both on my own involvement in sanctions-related cases and on a review of past decisions, is that overall, domestic courts and arbitral tribunals are somehow reluctant to give effect to extraterritorial and secondary sanctions in the context of contractual disputes. I'll elaborate, but very briefly. To this day, the characterization of economic sanctions from a private law perspective remains cause for debate. Is the prohibition to perform certain transactions laid down in a sanctions program, is it to be regarded as a legal rule that one of the parties might have to comply with, alongside with the provisions of the contract and the applicable law? Or is a sanction, including the risk of enforcement measures and the risk of penalties that it entails, is it to be regarded as a datum, as a set of factual circumstances that might interfere with a party's ability to perform its contractual obligations? So interestingly, scholars have analyzed rather in detail the strengths and the weaknesses of this legal approach and this factual approach in an effort to determine which one should be followed as a matter of principle. And counsel are increasingly aware of the fact that choosing one of the approaches rather than the other might have important strategic implications when it comes to defending their clients' interests. But those that are ultimately the decision makers, domestic courts and arbitral tribunals, usually implicitly rely on one or the other of these approaches without even acknowledging the existence of a debate. And whereas they typically reach the conclusion that primary territorial sanctions do constitute impediments to the performance of contractual obligations, for a multitude of reasons that we explore in the book, they often reject arguments, whether the arguments be of a legal nature or of a factual nature, that are raised in support of the position that the existence of extraterritorial or secondary sanctions should excuse a defaulting party's non-performance. And in fact, even in those instances in which such sanctions are effectively regarded as giving rise to an impediment to performance, exemption from liability for non-performance is very often denied on the ground that with efforts and expenses reasonably greater than anticipated, the defaulting party could in fact have overcome the impediment. It could in fact have performed its obligations without breaching the sanction and without evading it, and its non-performance should therefore not be excused. For instance, in one of our cases, I witnessed an arbitral tribunal deny a defaulting party exemption solely on the ground that this party could have delivered a commercially reasonable substitute so as to overcome the consequences of a sanctions program that prohibited exports of goods manufactured through technology developed in the sanctioning state. The second observation, it has to do with the non-alignment among states when it comes to the lawfulness of extraterritorial and secondary sanctions, which was already mentioned before, and the consequences of this non-alignment for private operators. So blocking statutes were mentioned earlier. The blocking statutes have been enacted in reaction to a number of extraterritorial and secondary sanctions, primarily US sanctions, on the ground that the scope of these sanctions exceeds the boundaries of the sanctioning state's prescriptive jurisdiction under rules of public international law. It was mentioned before. And so basically, what these blocking statutes do is that they prohibit operators that are within the jurisdiction of the blocking state from complying with these sanctions. Now, the parallel and conflicting existence of blocking statutes and sanctions is bound to throw private operators in a quandary. If a transaction falls both within the scope of US extraterritorial or secondary sanctions and within the scope of a blocking statute, what should the operator do? Suspend performance of a transaction that is targeted by these sanctions and risk incurring penalties under the blocking statute? Perform the transaction and subject itself to the wrath of US law enforcement agencies? Well, the Court of Justice of the EU, one of those two cases you mentioned, has relatively recently pondered on this question in the context of the EU blocking regulation that was adopted in reaction to the extraterritorial reach of US sanctions imposed against Cuba, Iran, and Libya. And interestingly, the Court of Justice has reached the conclusion that if an EU operator would suffer a disproportionate loss due to penalties that would be imposed if it were to perform a contract targeted by extraterritorial or secondary sanctions, then courts in EU member states have the authority to allow this operator to suspend or to terminate the contract, despite the prohibition as a matter of principle under the EU blocking regulation, the prohibition to comply with these sanctions. Now, the interesting question remains, how will this proportionality exercise or test operate in years to come? What weight will be given by domestic courts to normative policy, to the public policy objectives of the blocking regulation, as opposed to factual considerations of hardship? So far, if we look at the case law, it suggests that factual considerations of hardship may only be relied upon in limited circumstances, that usually the EU's normative policy prevails. But change is not inconceivable. The US Department of Justice is clearly endeavoring to enforce much more aggressively its sanctions programs, with the risk that penalties be imposed much more systematically. So could this make courts outside of the US more amenable to an operator's argument that the risk of such penalties in and of itself calls for some sort of relief? More importantly, in my opinion today, what about what Tom mentioned earlier? What about the expanding reach of some non-US sanctions programs that have traditionally claimed not to have extraterritorial ambitions? So if we look indeed at the EU sanctions program against Russia today, it not only requires EU operators located outside of the EU to comply with EU sanctions, like other EU programs, but it also seeks at least to influence trading patterns of non-EU operators, as Tom mentioned, in a manner that might be and has effectively been considered, regarded as tantamount to secondary sanctions. So it's fair to ask, if the EU itself is seen as imposing secondary sanctions, will domestic courts in Europe become more amenable to allowing operators to suspend the performance of their obligations on account of their exposure to US sanctions? And that's not just a fundamental question from a policy perspective, it's a question with eminently practical ramifications for private operators and their counsel. So I think my 10 minutes are up. It's short, 10 minutes, it allowed me to share a few thoughts, but I'm happy to discuss questions or practical examples. Thank you.
Thank you very much. And now on to our final speaker, last but not least. We have Ivo Amar, who is an attorney at law at the Avocats in Amsterdam. So please, the floor is yours.
Thank you. Indeed, I'm Ivo Amar, a lawyer in Amsterdam. I have been a lawyer for 17 years, specializing in sanctions for 12 years now. Sanctions and export controls only. So we don't do the legal procedures in civil law. I've done that in the past, but we advise our clients on sanctions and export controls. My idea is to keep this a little lighter, since I'm the last speaker, to talk a bit about my experience in sanctions. And I'm going to start by disappointing you. I have never done a secondary sanctions case. And I think that already in itself shows the effectiveness of the secondary sanctions. Why? Because they are effective without enforcement in itself. Now, what I found interesting to read in the proof of the book, but also in your story, Tom, is that there are apparently different versions of secondary sanctions. I always used to think that secondary sanctions are those specifically targeted on individuals or specific transactions that are subject to secondary sanctions. But I fully agree, the extraterritoriality of sanctions is broader than, especially that in the US, is broader than the secondary sanctions as I used to know them. And in that sense, actually, the very first case I did was the ING case. ING in, I think, 2012 was already subject to enforcement by OFAC for having done US dollar transactions with Iran and Cuba at the time, and Libya, if I'm not mistaken. They ultimately settled for over 600 million euros. And they settled because they didn't want the Department of Justice to be involved. Of course, it was involved in the investigation, but ultimately it wasn't involved in the enforcement. And that is how most of these cases ultimately are fixed. They are settled. And that is also why there's so little case law. There's case law in the US, but there's so little case law in the US. And that actually allows the OFAC and BIS to ultimately extend their jurisdiction onto many other types of transactions. So in practice, we do advise a lot of our clients on how to deal with sanctions and the extraterritoriality of US sanctions in particular. But on the secondary sanctions, the very specific secondary sanctions, there is very little to be said. I think we've heard a little bit about it today. Very often we get clients that want to enter into a transaction with a country that is possibly subject to secondary sanctions, or a transaction that is possibly subject to secondary sanctions. And then we tell them, there are secondary sanctions. They are subject to enforcement under specific conditions, under specific circumstances. That it has to be a significant transaction. And there are conditions for that. If you meet that, then in principle you are subject to enforcement in the US, maybe placed on the sanctions list yourself. On the other hand, there's the blocking regulation that says you can't do that transaction. So it's up to you ultimately to decide. Very often they say, well, it's okay, we'll leave it at that. Every now and then they say, well, listen, it's not a significant transaction. I think we can do this. And so it sometimes happens. So yeah, that's basically what we do with regard to secondary sanctions. Like I said, yet they are the most effective form of sanctions. And I read in the book as well, they enhance the effect of primary sanctions. And I think that is absolutely sure and absolutely clear. I mean, the secondary sanctions are the reason we don't do business with Iran. The secondary sanctions are the reason we don't do business with Cuba. Back in 2015, I remember it was in December. I was asked to come together with the Minister of Foreign Affairs in the Netherlands, Mr. Kamp, to Iran. At the very first, it was still called a fact-finding mission. We weren't allowed to call it a trade mission because trade wasn't allowed at that time yet, because in January 2016 the sanctions were lifted. we got there. It was a mission for the agricultural sector and a mission for oil and gas. There was this one representative of the University of Wageningen, and we went to this large, very large agricultural company. And the representative of the University of Wageningen said, I know a lot of these flower cutting machines, but I've never seen this one. And he asked the farmer, how did you get this flower cutting machine? And the farmer started to smile and said, it's from America. And it really shows that ultimately even having the secondary sanctions doesn't cut it all the way. But when in 2018 Trump shut down Iran, and it's been discussed today already, reinstalled the secondary sanctions against Iran, the next day, and we did quite a few transactions with Iran in the meantime for large companies where banks said, okay, there's benefit for us as well, we can do that transaction. The next day the sanctions were imposed, all the banks said, no, we're not going to do business with Iran anymore. And said, not because of the sanctions, no, we've changed our policy. Because of course, if they said it was according to the sanctions, it would have been a criminal act. No, they changed their policy, and ever since we've not done business with Iran. I mean, I've just discussed with my colleague who's in the back. She asked, "Have you ever done any transactions via Instex?" I'm not sure if you're all familiar with that system. Instex was basically an entity set up by the European Union to facilitate payment transactions from and to Iran. And I know I once spoke to the compliance officer of Instex, and I said, "How are you doing?" He said, "I have nothing to do. I'm here, but there's no one here." I don't think they've had one transaction because I always said from the beginning it's a solution to a problem that doesn't exist. The problem wasn't that we weren't able to pay to Iran. We were perfectly able to make payments to Iran. If you wanted to, you could do it via all sorts of countries, and ultimately it would end up in Iran. The problem was that the financial institutions here in Europe didn't want to receive any funds related to Iran because they were afraid of secondary sanctions. And so, like I said, they are the most effective sanctions that we have. And for that reason, I think in 2022, I'm talking about myself a lot, I was invited by the European Commission to talk about the effectiveness of the sanctions against Russia. We were in the war for half a year, 6 months only. And at that time, the sanctions were relatively standard. We all knew the specific types of sanctions. We had seen them before. These days, that's completely different. And then we discussed and we said, well, they aren't really effective what we're doing now. We see a lot of circumvention. There was a lot of circumvention going on. I said, why aren't we considering secondary sanctions? Coming from a lawyer, that sounds really strange, of course, but I was just wondering, why aren't we considering secondary sanctions? And I was almost removed from the room. But here we are, 2 years later, and we still aren't allowed to call them secondary sanctions because that's what I hear, at least from the Commission, because ultimately they relate to goods that come from the European Union, and for that reason they aren't secondary sanctions. But of course they are, and not only the indirect. The companies that we are targeting outside the European Union for having breached or circumvented the Russia sanctions, but also the no Russia clause. I mean, we are asking operators in third countries not to export goods to Russia. The best efforts clause, which is, I think, one of the hottest topics in the market at the moment, really a struggle. Companies have to use their best efforts to prevent subsidiaries outside the EU, so companies that are not subject to EU jurisdiction themselves, to comply with the EU sanctions. And in many countries, that's not really an issue. I mean, if you have a subsidiary in Turkey, could be an issue, but very often they are willing to comply. But if you have a subsidiary in Belarus or Russia, I can assure you that company will not comply with the EU sanctions because it's prohibited in those countries to comply with the EU sanctions. So having to use your best efforts to do that. Of course, you can't do the impossible. That's also what the European Commission says. But still, it's a very difficult sanction to apply, and it's definitely something that could be considered a secondary sanction, I would think. I've spoken to public prosecutors in the past, and I think that is, and Cedric, you mentioned it already, that is the big problem here, at least in the European Union. There is no enforcement of this blocking regulation. And the public prosecutor at the time, this is quite a while ago already, said to me, "No, listen, I'm not going to enforce the blocking regulation because I wouldn't see how we get to a penalty ultimately. I would have to prove that they've complied with the blocking with the U.S. secondary sanctions. It's so difficult. I'm not going to do that." And I think that's the problem. Although the European Court of Justice has tried to give a bit more teeth to the blocking regulation, ultimately is quite a dead letter, to be honest. And the result is like I said, just after the secondary sanctions entered into force, companies just said, we've changed our policy. We don't want to do business with Iran or Cuba anymore. And for that reason, we're not doing business with those. Now, finally, and I think that's a very interesting development as well, is of course China. First of all, because the US is implementing export controls more and more as in a way that you could consider sanctions. I think a very good example is the foreign direct product rule, which says if you produce an item here in the Netherlands in a facility that is running on US technology, and you want to sell that item to Huawei in China, you need a license from the BIS in this case, and you're never going to get it. So basically, we are using export controls as sanctions, and that is very interesting. The other interesting element is, I think, China also having a blocking statute, not doing anything with it at the moment. Well, I believe they've done a little bit with it, but it's not that relevant yet. But once China starts to enforce these types of blocking regulations, but also their own export controls and sanctions, we get into a situation where we have blocks of countries, and it's going to be very difficult to navigate that. And it's also going to be interesting which companies is going to choose which type of sanction to comply with. So I think that's for the future. That is what we will have to look at. I've run through my notes and I've run through my time as well. So thank you.
Thank you very much. Thank you very much, Ifo, for this personal intervention, and to all the panelists for this panel. So we have time for a couple of questions. I know we've run a bit over time, so if you need to leave, please feel free to. But again, we have two colleagues. I might stand over there so I can see all the hands, but I already see one at the back. If we could start with that.
First of all, thank you for the presentation. My name is Juan Pablo Hernandez. I am Deputy Legal Advisor of the Embassy of Guatemala, although I make this question in a personal capacity. My question is for Professor Azeredo da Silveira. So you talked about the conception. There is one of the conceptions of these sanctions cases where they are considered from a legal perspective instead of a factual perspective. So my question would be, in which cases, if any, these sanctions cases should be considered as implicating the illegality and therefore the invalidity of an international contract? Thank you.
Maybe if we can collect a couple of questions and then we can have a round of answers, if you don't mind. Are there any other? So I see a lady in the back.
Hi. Thank you so much for your presentation tonight. And should I say, my name is Sharon. I'm an international law researcher. At the same time, I'm a journalist. So my question is, could multilateral sanction frameworks or increased reliance on global institutions provide a more legally sound international cooperative approach to achieve sanction objective? I have one more question. How do secondary sanctions align with norms in international economic law, especially regarding extraterritoriality?
Thank you very much. Are there any final questions to add to this round? No, then I think we can go to the panel.
Then the mic has to go back to the gentleman who asked the first question. I understood your question referred to what I referred to as the legal approach, but what exactly was your question?
So my question is, in some legal bodies, and I will use legal bodies in a very broad sense, for example, the unilateral principles, there is a distinction, a very clear distinction between force majeure, hardship, and illegality of contracts. So my question would be, if there is any case, any sanctions case, where the sanctions legislation should be considered a cause for the illegality of the contract rather than a cause for, as an impediment to performance.
I think there are cases in which our firm was involved where the question of illegality was raised in relation to sanctions. Primarily the question as to whether it was force majeure or illegality was the timing of the sanctions. Was the contract entered into after the imposition of sanctions, and were we dealing with a question of illegality, or was the sanction imposed after the conclusion, after the valid conclusion of a contract, non-illegal contract, and the performance was, there was an interference with the performance of the contract, and that was tantamount to a question, or was a question of force majeure, potentially a question of hardship. Now, in both cases, you're right that in the first one, which is the contract is entered into after the imposition of sanctions, it's usually you're going to look at sanctions as a legal instrument. Where the dichotomy is particularly interesting is in the other case for the performance. In case you look at sanctions as a legal instrument, obviously, for there to be a legal impediment, the sanction has to, from a private international standpoint, give an instruction. So either the sanction should be part of the applicable law, or the conditions to give effect to the sanction as an overriding mandatory rule, as a foreign law police, must be met.
Are there any other reflections or responses to the questions?
I think I'll take the one about multilateral sanctions and international economic law and extraterritoriality. So starting from multilateral sanctions, I mean, what we call multilateral sanctions is when they are adopted by the Security Council of the United Nations. And in that case, from a legal standpoint of international law, that's not a problem, because then there's a whole provision in WTO law saying this, that, you know, if there are sanctions adopted under the UN Charter, that's allowed. Now, whether the General Assembly could do the same would be an interesting question. They've tried a few times. And then also you also have, of course, Article 103 of the UN Charter that says itself that the UN Charter prevails over and the obligations deriving from the Charter prevail over other obligations. So I think that wouldn't be an issue. Your other question, it's interesting because the issue of territoriality, it doesn't work very well for international economic law normally, because in a way it's never extraterritorial, because you're always just imposing measures of, let's say the coercive measures you're applying are being applied against companies or things that are happening in your country. So it's not like the United States is going to say they're going to bomb a bank in Germany. What they're going to say is you're no longer allowed to conduct transactions using the US dollar and the mechanism that we support, or you no longer have access. So in that sense, it's never extraterritorial. But of course, this is not what we mean. What we mean is that you're affecting, you're relating to, you're issuing determinations based on the protection of a non-economic value that you're trying to protect somewhere else rather than in your country, right? And there was a big discussion about this in the beginning of the WTO. The panels in the appellate body have sort of circumvented this question by saying that the word in the territory doesn't really appear in Article 20 or Article 21. It says that it's your essential security interests regarding ABC. So there's nothing there saying that your essential security interests have to be something that is happening inside your country that you can identify. Similarly, and again, there's a lot of, this is an issue that hasn't been 100% settled, but I think it's being 99% settled, especially now that we have some climate change cases where it say, yes, you are allowed to condition imports, for example, on sustainability requirements happening abroad, provided that you can show that that's going to affect you at some point. So the categories of territorial and extraterritorial don't really work for trade law for this reason. So we thought that's not a concept we use. That said, of course, I think everybody can understand that there's a problem, and developing countries feel very well and complain about it all the time. Not only, and not only this issue of sanctions, but also in the whole issue of sustainability requirements, anti-deforestation regulation, carbon border adjustments, and all that. So I can't do the moralistic international law professor and say this is not allowed under WTO law, but on A, it's not exactly not allowed, and B, I think this is the world we live in, and in a sense there is a point, right? I mean, especially when you come to climate change. Yes, something that is being produced in India or China or Brazil, I'm from Brazil, it does affect the interests and ultimately the lives of Europeans, and so you can no longer think in these territorial boxes anymore. Thank you.
Before we finish this panel, Celia or Ifo, do you have anything you would like to add? Any final thoughts? No? So I'd like to invite you to give a round of applause for the second panel. And before I give some closing remarks, Cedric, do you want to say a couple of things?
Sorry for going slightly over time, but I hope we've come to an end now of what was a very instructive evening, I hope, and we hope that you will be able to read or consult or peruse the book once it will be out in early 2025. Thanks again to all the panelists, thanks to the AZHA Institute, and of course, thanks to you for spending the evening with us. And let's hope that the best candidate wins the US elections tonight. Thank you, and see you later.
Welcome